Court come to order, remain seated.
Okay, we're about to have a verdict in this case. I'm just going to caution again the audience. This is obviously an emotional case. It's been difficult to try and hear. Very important to keep your emotions in check when the verdict is read. The deputies are going to remove you if you have an outward reaction.
All rise to the jury.
Mr. Foreman, have you reached a verdict?
Yes, Your Honor, we have.
And was it unanimous?
Yes.
Has the verdict been filled in, signed, and dated by you? May I see it? Would you like to publish this verdict, or would you like me to? The jurors not to be shown on camera. Yes, please.
On count one, order, we the jury find the defendant guilty. Count two, felony murder in reference to aggravated assault. Count four, we the jury find the defendant guilty. Count three, felony murder, but criminal damage to property. Count seven, we the jury find the defendant guilty. Count four, aggravated assault on Secoriea Turner. We the jury find the defendant guilty. Count five, aggravated assault on Turner. We the jury find the defendant guilty. Count six, aggravated assault on Omar Ivory. We the jury find the defendant guilty. Count seven, criminal damage to property in first degree. We the jury find the defendant guilty. Count eight, possession of a firearm during the commission of a felony. Reference to count 1 to 7. We the jury find the defendant guilty. Count nine, violation of the Gaming Act. 15, Act 15, Act 4A. Reference to count 1 to 8. We the jury find the defendant guilty. Count 10, violation of the Gaming Act. 16, 15, 4B. Reference to count 1 to 8. We the jury find the defendant not guilty. Count 15, possession of a firearm from commission of a felony. Count 13, 14. Read jury finding defendant guilty. Count 17, violation of the Gaming Act 1654A with respect to count 13 through 15. Read the jury finding defendant guilty. Count 18, violation of the Gaming Act 1654B with respect to count 13 through 15. Read the jury finding defendant not guilty. Count 19, violation of the Gaming Act 1654E with respect to count 13 through 15. Read the jury finding defendant not guilty. Count 20, violation of the Gaming Act 1654E with respect to count 13 through 15. Read the jury finding defendant not guilty.
Okay. May I have that again? And will the attorneys come up to make sure it's proper in form? Thank you. Your proper in form? Okay, thank you so much. Any requests before we excuse the jury? Okay. Okay, members of the jury, there are several questions that I need to ask each one of you, other than the alternate who did not vote. So let's begin on the front left with the foreperson. Will you rise? Was this your verdict in the jury room?
Yes, sir.
Was it freely and voluntarily made by you? And is it still your verdict? Thank you. Ma'am? Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Thank you. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Thank you. Was this your verdict in the jury room? Was it freely and voluntarily made by you? Is it still your verdict? Thank you. Sure. Was that your verdict in the jury room? Was it freely and voluntarily made by you? Is it still your verdict? Thank you. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Thank you. Was that your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Thank you. Now skipping over the alternate. Ma'am, was this your verdict in the jury room? Yes. Was it freely and voluntarily made by you? And is it still your verdict? Thank you. Sir, was this your verdict in the jury room? Yes. Was it freely and voluntarily made by you? And is it still your verdict? Thank you. Sir, was this your verdict in the jury room?
Yes, Your Honor.
Was it freely and voluntarily made by you?
Yes.
And is it still your verdict?
Yes.
Thank you. Ma'am, was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Thank you. Was this your verdict in the jury room? Was it freely and voluntarily made by you? And is it still your verdict? Thank you. Members of the jury, I'm going to release you to go to the back. Sentencing is likely to follow in just a few moments, so if you'd like to stay and observe sentencing, you can. But you can also be released. So if you'll step in the back, I'll meet you in the back.
All right, to the jury.
I'm sorry? Okay, I'll give you a few minutes to get organized for sentencing, and I'll be back in just a few minutes. Jurors are going to stay to observe. Do we have anybody from the defense in here? Would you come up? Mr. Investigator, will you come up? And just one of you guys so I can update you.
no one, I seen no one show remorse. And she should be sentenced to send him to the mat. He should pay for what he did to my daughter. She was innocent. She ain't deserve it.
The jury this afternoon. As to count one, murder, the state's recommendation would be life without the possibility of parole. As to counts 2 and 3, the felony murder counts, they would vacate by operation of law. As to count 4, the aggravated assault with a deadly weapon, in regards to Ms. Secoriea Turner, that would merge with count 1, Your Honor. As it relates to counts 5 and 6, which are the aggravated assaults with the deadly weapons charges for Ms. Charmaine Turner and Mr. Omar Ivory, the state would recommend 20 years to serve on both of those counts. As it relates to count 7, criminal damage to property in the first degree, the state's recommendation is 20 years to serve. As it relates to count 8, possession of a firearm during the commission of a felony, 5 years to serve. And count 9, the criminal street gang count as it relates to subsection A, 20 years to serve. Counts 13 and 14 are both aggravated assault counts. In regards to Mr. and Mrs. McCord, 20 years to serve. Count 15, possession of a firearm during the commission of a felony, 5 years to serve, Your Honor. And then count 17, possession of a count 17 is the gang count as it relates to subsection A, 20 years to serve. State's recommendation is for the sentence for each, recommended sentence for each to run consecutive, Your Honor. Let me double check. I do not think.
his mom would like to speak on his behalf. If you want to do that now or...
Your Honor,
Whether swear in or...
I can swear. Sure. Robin Conley, ROBYN-CONLEY. Your Honor, thank you for allowing me to speak. I recognize the gravity of this moment and the solemn responsibility that you carry in determining my son's sentence. I begin by acknowledging that a life of a beautiful child was lost, no doubt. I know the courtroom bears the weight of that loss, being a former Fulton County Police Academy instructor in law enforcement my entire life. And my family's history in law enforcement, my son's intention was to go down to the march to support people, Black people, that some citizens had determined that were victimized. He was named Julian because of Julian Bond, the late congressman. In 2000, Julian Bond narrated a PBS documentary called "Oh, Freedom After All," which was about my great-grandfather and great-grandmother going to the White House, being invited by President Roosevelt in 1939. So civil rights has always been in our blood. As a result, Julian would like me to say that he is truly sorry for the loss of Secoriea Turner. I prayed with Charmaine and I expressed my sadness. I acknowledged Secorea's father in this moment, and I pray in their hearts, if because the court said that he did this, that they can forgive him. I speak to uphold fairness, context, and constitutional values. My son has been confined for 5 years, awaiting this trial. During that time, I've witnessed his endurance under conditions that test limits of human resilience. In the Fulton County Jail, our own Guantanamo Bay, my son was forced to survive, being locked away 23 hours a day, with 1 hour out, with no running water in his cell, being given bags of ice. I understand it's not about him, but it is about him, because he was 19 when this happened. He's 25 now and has a child of his own. This case has raised serious questions about pretrial confinement with 5 years to get here, access to counsel, the presumption of innocence, and I ask the court to consider not just the facts of the case, but the broader context in which Julian has been held. Justice has been a punishment for him, but it must be principled, and I understand your role. I respectfully ask the court to consider a sentence that reflects the time already served, the potential for growth, and the constitutional values that we claim to uphold. Leniency is not the absence of accountability, Your Honor. It's the presence of proportionality. Julian deserves a future shaped not only by his consequence and circumstances, but by his possibilities of life. Despite the video shown, Julian has completed about 14 certificates while he's been in the Fulton County Jail. I understand the jail is just for temporary detainment. However, the conditions, again, are horrible. I speak today not just as a parent and a grandparent of Julian's child, but as a citizen who's always believed in justice that sees the whole person. Thank you for your time and consideration, Your Honor, and again, to the parents and family of Secoriea Turner, my family's heart and my heart goes out to you always. Thank you, Your Honor.
And Your Honor, on behalf of Aisha Broderick and Sean Hoover, as we stand here with Julian, I just want the court to know the person that I've gotten to know over the course of the last few years, and I've gotten to know quite a few people over the course of the last few years, but I've not gotten to know many like Julian, the way he expresses himself. And I can't tell you how many times I've met with him, and the first thing he's always said to me is, "I'm so sorry about that baby's life." He always says that. He always asks me, do I know anything about how the family's doing? He's able to do that while also never wavering from his initial statement way back July 13th of 2020. He's very sorry for that loss. But in his heart, he knows that he didn't pull the trigger that caused that young lady's loss, but that part has been determined. But he is someone that, if given a chance to do better with his life, and if given a chance to do better with encouraging other people to do better with their lives, and if given a chance to encourage his child to do better, he will take every opportunity to better himself, and he will take every opportunity to better all of those who come in contact with him. And that goes for what he will do while in prison, but I'm asking that he has that opportunity outside of prison. I'm asking that, I know the court's hands are tied, but to the extent the court has lenience, I'm asking the court to exercise that lenience. I'm asking the court to allow for the possibility of life on the other side, so that he can grow, he can be a person in society that society can look at and say, you're doing the things you're supposed to do now. You're a valuable, contributing part of society, and I'm asking for the court to recognize that he has that potential and to allow that potential. So I thank you.
can be seated. I want to start by saying I really appreciate the comments from the Turners and also from Mr. Conley's family. I hear you. Both families are serving sentences in their own way. So many things were going on at once on University Avenue on July 4th, 2020. I'm your third judge, Mr. Conley, and I've only had your case for a few months, but it immediately became clear that this is a case fraught with conflict and a tragedy. There were individuals that day exercising their First Amendment right to gather in support of a cause held dear. There were individuals simply observing the goings-on. And that day, Mr. Conley, you and your colleagues were there in a massive show of force at an illegal barricade, brandishing heavy weaponry, demanding respect, and deciding that day who could pass and who would be terrorized. That day, on their way home, Mr. and Mrs. McCord were not deemed members of the community. For some reason, they were not allowed to pass. And we observed a shocking video in which you and others prepared to shoot if defied by Mr. McCord. And by defied, I mean if he simply drove down a public street. We saw a video of you scanning inside public transportation to determine if Marta could pass through, AR-15 in full display. And of course, we saw the video in which you and at least one other person, maybe more, fired on the vehicle carrying young Secoriea. Your actions demonstrated that day an abandoned and malignant heart, a reckless disregard for human life. You didn't have to know there was a young child in the back seat. You fired on a car that you knew was carrying human beings. And in an area where children were present. It's so fortunate that only one child died that night. We don't know if the jury found you responsible because they believed the state proved your bullet pierced Secoria's body or because they found you were a party to a crime. It does not matter. Secoria's parents are serving life sentences without their child. For Ms. Turner, a life sentence in which she relives trying to rescue her baby daughter, trapped in a seatbelt, asking for help, dying before her. Well, she screamed, "Please help, please someone help." Hopefully, closure happens today with this verdict. Mr. Conley, you put a lot of effort into telling the world that you're a dangerous person. We saw videos of you acting as a self-appointed enforcer on July 4th, the videos brandishing weapons, and even this year in our jail, brandishing weapons in the jail with other people. Mr. Conley, I believe you, and that is why this will be your sentence. On count 1, murder, the sentence will be life without parole. Counts 2 and 3 will vacate by operation of law. Count 4 will merge. Now, Mr. Conley, you've comported yourself very well during this trial. And because of that, I'm not just stacking every one of these consecutively. Counts 5 and 6 will be 20 years apiece to run concurrent with the other sentence. Count 7 will be 20 years to serve to run concurrent. Count 9 will be 20 years to serve to run concurrent. And counts 13 and 14 will be 20 years total, 20 on each, to run concurrent with each other, but consecutive to the life without parole sentence. And then finally, count 8 and 15 will run consecutive to all of the other sentences, but concurrent to one another for 5. Oh, and count 17 will be 20 to serve, concurrent. So a total of life without parole plus 25 years. I'm not just going to stack all of them. You've comported yourself well during this trial, but because of your reckless disregard for the life of this child, I feel I have to sentence you to life without parole. Okay. Mr. Abadi, will you go over his appellate rights?
You'll have 4 years from today to file what's called a habeas petition challenging the proceedings, the voluntariness and the constitutionality of what occurred during the trial of this case. You have 30 days from today to file a motion for a new trial in regards to the trial from the last 2 weeks.
That's okay.
As relate, and then 30 days from today to file a motion with the Supreme Court that relates to a direct appeal or in the term of this court, whichever is longer.
will the defense team go ahead and file his notice of appeal and his preliminary motion for new trial?
Yes, Your Honor.
Okay, thank you for doing that. Okay, and new Mr. Conley, new counsel will be appointed for you for appeal. Okay, thank you, everyone.
If we go family to remain seated, we'll tell you the order that you'll be meeting. Your family and friends.